Mr. Whitefoot, did you have a chance to go through that report again with Mr. Gurmurthy?
Yeah, it's where I have absolute better understanding, and a refresher is always good.
Okay. Mr. Gurmurthy, are there any additional deletions or corrections to that report?
No, just not.
Just the scoring of the guidelines.
No.
Ms. Coe, do people have any additions, deletions, or corrections?
No, Your Honor.
One question I had, just because it seems like a high amount here, the restitution requested is in the report is $40,000.
It was the ATM was broken at the bank, and they actually, I don't know if they've replaced it, but it's not there anymore. So that's just the number that they sent to us.
Did they provide you any kind of documentation?
Let me check. They gave us the $5,000 for the cleanup, $10,000 for the rigging, $19,000 for the replacement, and $6,000 for the gate replacement.
Okay.
So-
All right. Because Mr. Whitefoot didn't actually get any of the cash, right? He didn't-
No, they didn't stretch.
No.
No, he didn't break into get the cash.
Attempted
Attempted to get to the cash.
Attempted very hard with tools.
Yeah, okay. I'm gonna attach this receipt and restitution report as part of the PSI. I just want to make sure that there was some documentary justification for the amount. Ms. Koch, do you have any objections to the guidelines as scored?
No,
Do you have any victims that wish to address the court today?
they did not.
Anything by way of elocution I'd be happy.
Of course, aware of what happened. I mean, Mr. Whitefoot clearly was trying to break into the ATM. He made the admissions early that he did it, and the recommendation here is 12 months in jail. Whether or not, I debated whether or not to ask for the 13 months or 14 months for prison. But he doesn't really have a very lengthy criminal history. So I'm not really sure what made him think this was a good idea. This is someone who's only 30 years old with only 2 misdemeanors. It seems kind of bizarre behavior. I understand that he has some mental health issues that he is addressing or needs to address. So I'd ask the court to follow the recommendation.
Thank you, Mr. Gurmurthy.
Just by way of some background, so the record is clear. Mr. Whitefoot pled at the initial arraignment. I think Mr. Trush was the arraignment attorney and advised him to plead not guilty. Wait till the discovery was here, we could negotiate a plea. And Mr. Whitefoot's indication was, no, I want to plead guilty and plead as charged to the complaint at that point. And that's what he did. And so he tendered a plea at his arraignment, and then this was set for sentencing. So that's why we're here in such a short time. And he waived his right to an exam, waived his right to the probable cause conference. When I met with Mr. Whitefoot, my understanding is he was very open and honest about the crime that he committed, and he committed this crime because he wanted to get caught so he could be incarcerated because he was having a difficult time finding employment. And the best way for him to have some oversight was
be fed with the
Mr.
roof.
Whitefoot, I'm gonna give you a chance to speak here in a minute. We're making a transcript of this, so you can only have one person talking at a time. Okay? Can you wait until Mr. Gurmurthy's done?
I will bite my tongue as best as I can, sir.
and wanted to be incarcerated, so there would be some oversight. But I'm trying to figure out what that oversight would be, whether that oversight is where he gets some services with help of getting employment, staying sober. But again, I wasn't able to identify any issues with substance abuse. So I'm at a loss as to what led Mr. Whitefoot to want to commit a life offense, one of the most serious offenses, with somebody who was 30 years of age with very minimal criminal history, and even his misdemeanors are very low misdemeanors, and only 2 prior misdemeanors, and then his guidelines are 0 to 17 months. There's a recommendation for 12 months, which I think all of those things are appropriate. But in representing a defendant, you try to understand the needs that they have and best tailor what those needs are. And Mr. Whitefoot has been unable to help me understand what those are. He has a completely different understanding of the system and what his goals are for him for the system to achieve for himself, and I don't think the system can do that. So I would just have the court hear from Mr. White, and what I would simply ask, I think, he's not a malicious person, he's not he hasn't been, he's indicated that people have called him as somebody that's hard to deal with. I haven't had that impression. But I still, I can't figure out what led Mr. Whitefoot to get to committing this offense, given his history, given employment, given some of the things I know about him, but I just can't bring those dots. So again, I would ask the court to hear from Mr. Whitefoot and follow the recommendation.
Thank you, Mr. Whitefoot. Anything that you would like to say?
I do believe I have pled an admission of guilt to multiple felonies. So the way that I look at that, because this is law, technically I am a felon. I don't believe in like the trickle down aspect of, oh, if you plead to a misdemeanor, now you can go get like a job with other corporations, when still other corporations and other systems that are set in place, if you already accepted that admission of guilt to that felony, you are considered a felon in their eyes. And it's actually policy for multiple corporations and businesses. So I was just wondering if we could just make it to where I am a felon, this would be the 9th felony committed before we actually ask for any charges to be set for it.
You are a felon. This is a felony.
Yeah, and then, but I want the court and the people of Michigan to actually look at it as I'm already a convicted felon.
They will look at that way. You are a convicted felon. The court records will reflect that.
Right, but I just want to make sure that it's not just like 2 misdemeanors from the prosecuting side.
It's not.
That it's like 8 to 9 felonies of
No, this is
racks.
felony safe breaking. So yes, you have what you're asking.
All right.
Is there anything else that you wanted to say today?
Nope.
Okay. I did read through the report, so I'm familiar with what you did, in this case, your actions. I'm also familiar with your background and your circumstances based on the information in that report. I take all of that into account along with what the lawyers here had to say. Your guidelines in this case call for a sentence of 0 to 17 months. So the court could sentence you to no jail time, it could sentence you to county jail, or it could sentence you to prison time. Some of the mitigating factors here, or the factors that work in your favor, is that you don't have a significant criminal history. One of the factors I think that works against you is your crime in this case. This is a very serious crime. And obviously it's got a maximum of life in prison. So the legislature looks at it as a serious crime. Despite your lack of significant criminal history, I think your actions in this case justify prison sentence.
Absolutely.
And so the court is going to depart from the recommendation to the extent that I do think, given your conduct in this case, given your mental health issues, the prison sentence is warranted for purposes of punishment. I think it's up to the court also for purposes of deterrence to show the community that you're going to engage in this kind of behavior. It's going to be dealt with serious consequences.
Yeah, good scapegoat. Very good.
Yeah. You did this, so you're not going to scapegoat for anything. I also think, given your mental health issues, those are going to be much better addressed through the prison system locally here. So for all of those reasons, I find the prison sentence is warranted. The court is going to sentence you to 16 months to 20 years in the Michigan Department of Corrections. You have credit for 52 days served. The court is going to order that you pay restitution in the amount of $40,000 that's payable to the Crawford County Clerk to be dispersed to Huntington Bank. The crime victim assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, $68 state costs. You have the ability to seek an appeal of this sentence, and Mr. Chairman, if you can provide.
You are right here. Yeah.
He does have his appellate paperwork, Judge.
Yeah. Yeah. And then can we do more of a max? Well, that would be part of the appeal, right, Your Honor? Instead of it being like a max of 20, you know what I mean? And how can I guarantee to get that 20 instead of it being, what'd you say, 16 to 20?
16 months to 20.
Yeah, and how can we just guarantee to where we just slam the hammer and it's 20 years regardless?
I don't have an answer for you. I don't know. you are remanded to the custody of the state at this time.
Take care, Your Honor.
You did.